What is probate like in Georgia? In many states, probate, the court-administered process by which someone's property and debts are settled after death, can be complex, expensive, and worth significant effort to avoid. Georgia, however, is an exception to this. Georgia is an easy probate state. Georgia law streamlines the administration of most estates that go through probate and allows many estates to avoid probate altogether. In this article, we look at what makes Georgia probate easier than in many other states. In Georgia, the probate process is only administrative unless a post-death dispute arises. The will, the petition to probate in solemn form, and, sometimes, the death certificate should be filed with the probate court in the county where the decedent lived. So long as all heirs are adults, consent to the petition to probate in solemn, and do not dispute the will's validity, the proposed executor swears to follow the terms of the will. After swearing, the probate court clerk provides the executor with Letters Testamentary, a document stating the individual is the estate's executor. From there, the executor handles the estate administration without court oversight or filings. Even with a streamlined process, probate in Georgia typically takes several months. Complicating factors, such as a minor error or a poorly drafted will, can slow the probate process. An experienced Atlanta estate planning attorney may be able to provide valuable insights on how to manage any potential disputes that may arise during the probate process. Further, in Georgia, you may not need a will at all. Most states have a simplified probate process called summary probate for small and uncontested estates. The qualifications for summary probate vary by state and are often driven by the value of the estate. Georgia is one of the few states that allows heirs to skip probate altogether. So long as there are no outstanding debts, all heirs agree to the distribution plan, and there is no will. Notably, Georgia does not put an estate dollar value limitation on the availability of this process. So long as the three requirements above are met, the process only requires that a representative of the estate file a petition with the court attesting to the lack of need for administration. This is a huge benefit for small, simple estates in Georgia. But for people with more complex estates, or who do not want to leave the disposition of their estate for others, or the state, to decide, comprehensive estate planning is advisable. You should discuss with an attorney whether your primary estate planning document should be a will or a revocable living trust. Contact an Atlanta estate planning attorney at Trace Brooks Law to discuss whether a will or a revocable living trust is right for you. Often, potential clients seek a revocable living trust to avoid probate. Probate in Georgia, with a well-drafted will that waives bond and inventory and reporting requirements, and gives all the correct powers to act without ongoing court supervision, is not difficult. There are, however, other reasons to use a revocable living trust as your primary estate planning document. It is important to note that the only assets subject to probate are those in your estate at death, and many assets can be transferred to your heirs upon death without a will or trust. For example, any asset that allows you to make a beneficiary designation, such as a bank account, life insurance, or retirement account, will transfer ownership to the designated beneficiary immediately upon your death. Similarly, any jointly owned property will pass to the surviving owner. The probate estate consists of everything left over after these compulsory transfers occur. Contact an Atlanta estate planning attorney at Trace Brooks Law today to discuss your options and determine how probate might affect your estate.